Boyd.
Here.
Barr.
Here.
Hobson.
Here.
Kirby. McCon. McDaniel. Parker. Simmons 12. Turner Ford. Here.
We do have a quorum. Senator Brannigan told me she'd be joining by Zoom, so we'll wait a minute. I'll look over.
Mr. Chairman, this is Barbara Blackman. Did you get
See if
me?
she's gonna. All right, well, we'll go ahead, while they're doing that, we'll go ahead and get started. We're gonna skip over the first one on the agenda and we'll go call up Senate Bill 2260, public official corruption, authorizing the Attorney General. This is filed by Chairman Fillingane at the request of the state auditor. In short, it is to authorize, if you look over at Section 2, it's allowing the Attorney General to investigate white-collar crime at the request of the state auditor. Honestly, I'm not sure. I didn't realize that couldn't be done, but this is allowing that to occur. And if you notice line 18 and 19, official corruption, and line 53, official corruption investigation. Again, this is coming from the state auditor trying to clamp down, or certainly give them the tools that they need to fight, unfortunately, some of the things. Oh, thank you. Thank you. We do have the committee's proposed committee substitute, and that was to fix the in line 38, 37, 38 to properly refer to the Transportation Commission. So that would be the proposed committee sub. So with that, do I have any questions?
I think I'm confused why we need this, because they have prosecuted in the past. But is this just maybe clearing up some?
Correct. That it is my understanding that, and I thought Senator Fillingane was here.
Okay.
That the state auditor did not have the authority. I'm sorry, the Attorney General could not investigate that. Also, let me say this, that it's prosecuted locally in different districts.
Right.
It's not taking that away, but what you have found, or in court, this is according to the state auditor's office, is that there are local DAs that are certainly give pause to prosecuting public corruption in the local areas, depending on who it is. So that's why this has been brought forward by the state auditor, so that when the state auditor goes in, currently, if they do an investigation, it then goes into that DA office for prosecution. This is allowing the to send it to the Attorney General for determination about prosecution. Senator Hobson.
Thank you, Mr. Chair. With respect to your proposed amendment, first of all, is the amendment to change, would the amendment change that from Mississippi Department of Transportation to Mississippi Transportation Commission?
Correct.
Even though I know that Mississippi Transportation Commission is throughout the code, but is the formal name of that the Transportation Commission?
The language that's there, the current language is Highway Commission, and then when it was to be updated, the bill that came in, they changed it to Department of Transportation. It should have been Commission.
And they called Ethan and asked.
They just said it's
that be
current
it.
law.
Yeah, I realize from having read plenty of code sections that it says Transportation Commission throughout, but I thought their formal name was now Department of Transportation, but I may be wrong. If they've requested that, then I would assume they know what their proper name is. On the final bill, I guess we need to move to adopt your amendment at some point. So that I'll ask
The
that
committee
question.
substitute, that's correct.
Well, you need an amendment to the,
No, you have before you a proposed committee substitute.
or do we?
It's separate from the packet.
Okay.
There it is. Yeah,
I didn't see that. I'm sorry.
that's the proposed committee substitute. Senator Turner Ford, you had a question?
Yes, Mr. Chairman, and this looks familiar. Did we take this up last year?
I wasn't in this committee last year. Okay, I'm hearing a nod, yes.
Thank you.
So we did take, and it was passed last year, right? So we did do that.
We passed it out of committee last year, but with kind of the caveat that we were going to look at it and see if actually this issue did come up last year. And we passed it with the caveat that staff was going to look at it to see if we actually did need this, given 7554 right here. And that's why I was looking back at it, because there seemed to be some clear authority that we do this. I understand that. I'm for prosecuting, so whatever we need to do, this, but there was some ambiguity of this last year.
Well, Senator Fillingane filed this bill.
Okay,
I think if that can, he's open to clearing that up
okay.
on that. So do we have a motion?
Motion.
Title sufficient, do pass. Committee substitute. Motion is title sufficient, do pass. Committee substitute. All in favor, say aye.
Aye.
All opposed? Motion carries. Okay. Next, call up Senate Bill 2352. This is one that this committee passed last year, and providing affirmative defenses for liquid petroleum gas providers. The short of it is, and we have Senator Tate, I'll do my best, and then it's your bill. So my understanding is that in parts of the state, people are go out and adjust or fix the gas wells and things like that, and the producers don't know it, and then they can get sued and be held responsible and held liable. And what this is, this isn't creating immunity, this is creating an affirmative defense. And if you look at the operative words are in line 16 and 17, an alteration or modification that was not reasonably foreseeable. So if it was foreseeable, then there wouldn't be an affirmative defense and cause the equipment to be unsafe. So that's really all it does. Senator Tate, you have anything? We have Philip Chambly here. Would you like to say anything? Yeah.
Thank you, Mr. Chairman, members of the committee. I'm with the Propane Gas Association, and this addresses the propane industry for retail propane installations, whether it's for homeowners or whether it's for a business. It just simply states that the current regulations require, that DA 54, National Fire Protection Code, and the statutes, that when a propane system is installed in a home or business, they have to perform a leak check. And they have to follow the guidelines. They have to keep a pressure on it for a minimum of 3 minutes. Most propane companies do it longer than that. They have to complete a form, which I have copies of here if you need to see one. These have to be sent in within 15 days to the Department of Insurance, actually the LC Gas Board, which is under the State Fire Marshal, which is under the Insurance Department. And so, they have to complete these forms, and so there have been instances where people work on their own systems, as the chairman said, out of heater, out of line, there's an incident, the propane company didn't know about it. So they may get sued for something they didn't do after they completed the paperwork. So this, I think, helps protect the consumer and the propane in that instance. You glad to answer your question?
And that paperwork and all is already current law that has to be done.
1948.
Okay, so any questions? Senator Hobson?
Thank you, Mr. Chair. While I'm supportive of this, and I am, but would this be the same, essentially a superseding or intervening cause that's normally allowed through the affirmative defenses? I guess I'll ask you first, Mr. Chair. You may have to defer.
My understanding, reading it is, and that it would be an affirmative defense, meaning that the producers would have to have the burden of proof to show that they came out and didn't have the knowledge and it met this standard. So I guess you could, we may be getting into some of that, it could be an intervening cause, but the difference is, putting on my law school hat, and affirmative defense means if the producers prove that, then it's an automatic defense to any recovery. Which I think would be the difference between the intervening side of it.
Yeah, the reason I asked the question is if I'm defending an LPG provider and I don't put in this specific affirmative defense, have I waived it? As opposed to normally I would just put in it's a superseding or intervening cause, therefore anything related to this would apply. And I'm afraid that if I didn't specifically put this in this case, I would hope that most people that are doing their work would know about this anyway. But if I didn't put it in, I may be out of luck. I may have created a problem for the LPG industry because I've not specifically identified this affirmative defense when I put in my generic affirmative defenses, such as superseding and intervening cause. And I wonder if this could end up hurting the LPG industry more if you didn't plead it specifically under the rules.
That's when you contact your E&O carrier. But I hear what you're saying, but this is coming to us from the industry itself. So I would think that they vetted that, and the lawyer, right? I mean, Philip?
Yeah, our lawyers looked at all this, and this was some legislation, chairman, that we got from another state.
Okay.
Thank you, Mr. Chair.
Senator Simmons?
Thank you, Mr. Chairman. I guess to expound a little bit more on what Senator Hobson said, I mean, is it even needed? I mean, because if there's litigation between someone who actually suffered injury or death as a result of any act or omission, wouldn't the Mississippi Rule of Civil Procedure allow, through the attorney for the LP, to argue, I guess, under 8B, any and all defenses, including affirmative defenses? Like, I guess if we should start, my concern is, do we need to, in all causes of action, in all industries, come up with a statute just to allege or assert what I would normally assert in an answer if I was defending a lawsuit? I guess, when do we stop doing that? I mean, I can name all type of causes of action, but I guess that's my concern. And to add a little more to what Senator Hobson is saying, are you sure this is not going to hurt the industry more than help the industry?
Our lawyers look at this. Of course, I'm not a practicing attorney, and I think the issue that we've been seeing, there's been some instances over the last 5 years where there was an instance where someone altered their propane system after it was leak checked, after the phone forms were sent in, required by law, and there was a loss of life or someone got hurt. There is a case in court right now. I don't have a case with me that is ongoing, and so we were just seeking to give a little more protection to the propane dealer who did everything right and filed his forms, but he's still getting sued, and he had no idea that someone had altered the system by putting in a new appliance or additional line without doing a pressure check on the system or leak check on the system.
But I think
Where is that case? Can you tell me where is that case right now?
I've got that downstairs somewhere. I don't have it.
Okay, can you provide me that
Yes,
case?
sir.
I think
know
what-
it's in North Mississippi.
Okay, all right.
I think what the attorneys are saying is an affirmative defense, you have to plead that, and if you don't plead that under the rules, then you waive that. If there's no requirement of an affirmative defense, then you're not missing anything. That's why these attorneys, and I know you're not an attorney, that's why these attorneys are saying, are you hurting yourself by asking for an affirmative defense? But if you're saying that the gas attorneys have vetted this and are asking for it, then I would think they would understand that. Senator Barnett?
Thank you, Mr. Chairman. This bill, we went over this bill last year. Never made it out of committee, and that was because of all of the questions and concerns. Some of them have been raised already today, but the other questions was that, it's the petroleum, not the petroleum, but the propane companies just saying that if I decide that I want to go out and buy a new space heater, gas heater, and install it at my house, then I have to contact them to make sure that they come and install it. And if it's a stove or whatever, then I can do it myself, but I got to contact them. I got to submit all this paperwork. So my question to them, again, this year is the same as it was last year. When you go and install a new light bulb at your house, we don't have to always call Mississippi Power. And there's also a risk of electrical fire, just like it is with with the propane fire that can happen. If we decide to change the sink out at the house to keep our house from flooding, we don't call the water company all the time to change that out. Why? Because those are things that the industry, I think, across the years have realized that the individuals can do some of them things for themselves. And this law is already in the books. Why do we need to change it? Why are we trying to just say that every time I change out an appliance at my house, I have to notify someone, then carry this additional paperwork to the courthouse or wherever it is to have it filed? I think that becomes a burden upon the individual, the homeowner. I think it's asking too much. I think the government, we're asking the government to do too much in the private lives of individuals. I can understand if it's a new installment. Yes, those things has to be done. If it's a new installment on the electrical system, all those things has to be done. But I think if they checked on that, if they have a checklist that they check off of and they make a note of all of the appliances and everything that was done, submit their paperwork, if something should happen, and I'm sure it will be investigated, and if they find that something was installed later on that's not on this list, then I don't think they bear any burden. I think that's becomes a responsibility of the homeowner.
Well,
So-
but I think, Senator Barnett, I think the purpose of this bill, that would be all nice and fine and tidy if the homeowner then didn't turn around and sue the company after they did the work.
But homeowners don't always, sue the companies when they change a light bulb.
Well,
So
I
we're
know,
talking about maybe one incident here, but homeowners don't sue the city if their home is flooded. Homeowners don't sue the telephone company when they go out and sell telephones that you can install yourself. So
is there a question, or are you speaking against the bill?
well, I guess I'm speaking against the bill because it was just
Okay.
excuse me for that. But my question is again as to the same as Senator Simmons asked. If it's already here in statute.
Well,
Then why do
let
we
me get
need
to the questions first, if you want, and then I'll let you. So, are there any more questions? Okay, Senator Turner Ford.
Thank you, Mr. Chairman. What I'm trying to understand with the, I guess, the fact sheet that you gave us, is there anywhere in the code that specifically prohibits a homeowner from adjusting or modifying propane lines?
Well, it does not specifically prohibit, but in the statute here since 1948 requires anybody who installs, connects, alters, extends, all those things, they have to submit the paperwork in 15 days, whether it's a homeowner, whether it's a certified installer. And that's the issue we're running into is people aren't submitting paperwork, the systems are not being leak checked, and it creates a hazardous situation for the homeowner.
So when we look at the bill as proposed, especially on line 17, my concern is this language refers to an alteration or modification of liquefied petroleum gas equipment that was not reasonably foreseeable. So is that standard identified anywhere in the code as what would be reasonably foreseeable as it relates to propane or this process?
I guess my answer essentially would be that they have to follow the regulations and rules set out by the LC Gas Board and the NFPA 58 or 54, National Fire Protection Code. There's a whole full code book of pressures, things they have to do when they put in the system.
And Senator Turner, the reasonably foreseeable would be a term of art that the courts would have to, I guess it's already defined. So the question would be, is what happened reasonably foreseeable? If it wasn't, if it was, then they couldn't do the affirmative defense.
So I guess my issue is if reasonably foreseeable is the language that is used in the statute, but it sounds like what you all want as an industry is that you do not want homeowners tampering with or modifying the propane lines. I don't see those two positions as consistent. The way I would say this is this to me kind of has a hole that you can drive a truck through, I guess this does not seem like tight language to prohibit someone from tampering with the lines if that's what you're trying to accomplish.
We're not opposed to language like that either. We're just trying to protect the homeowners and dealers and safety and all of those. But I'm not opposed to that.
And I think based on my conversation, I mean, they don't want people messing with them because it does create unsafe possibilities and all that. Senator Barrett?
Thank you, Mr. Chairman. If I'm understanding this proposed bill, it's asking, and I guess this goes along with what Senator Hobson said, this isn't asking for an absolute defense. It's just asking for an affirmative defense. Either you assert it or you lose it.
Correct.
Correct?
Correct.
Okay. I just want to clarify that.
That's right.
And it would still be a question that would go before the court.
That's correct. And as Senator Hobson put up, if they don't do it, then it's waived and be talking to your E&O carrier, I guess. So, or, yeah, Senator McDaniel.
I'm not really sure to address it to. I know you don't practice law. Well.
Oh, no, sir, I do not.
So there may be that as I address this, you tell me. I was trying to piece in my mind the litigation strategy behind this. And it seems to me that it primarily would affect dispositive motion strategy. If I were to file a motion for summary judgment, I would have an argument based on reasonableness of the language of this statute to attempt to strike the cause of action before it is to a jury. Does that make sense? If I don't have this in place, then am I not guaranteeing submission to a jury under the comparative negligence? So to the issue of the reason for the bill that exists, it would essentially not allow juries to give comparative negligence on the home. It would give a fiscal on your chance on the dispositive motion of this issue and strike. I think that's is that an accurate? I think that's what the bill is designed to do. Because I don't think it changes the law at all.
No, it does not change the law. We just want the propane dealer to have an affirmative defense. They left the system the way it was supposed to be. It met all the standards of the state fire marshal's office, there was a gas board. Then someone went in and tampered off the system afterwards and created a potential hazard that the propane dealer had no idea about.
I understand. I think Senator Hobson's question about affirmative defense is being raised. That was the most intriguing question. I don't need to come back and bullshit anyway. As a general rule, those affirmative defenses have to be raised in the plea. The answer. Although, Senator Hobson, I think your plea is reading calls, just receiving calls, that would surprise us.
Senator Hobson.
Thank you, Mr. Chair. That's a good question, because I think if this is specific, if this language is specific, that's what I'm concerned about, that if I didn't plead this specific statute, that I would lose on the superseding intervening cause, which generally covers things like this. And that's what concerns me. I'm not saying that it's not out there. I'm not aware of any other place in the code, in our entire code, that has a affirmative defense outside of Rule 8, which is for us attorneys, which it worries me, frankly, Philip, I'll be honest with you, it worries me that you would have this in here, because I would think unless you do that specific kind of litigation, if you hired any of us that don't do this on a regular basis, more than likely it's not going to get pled, and then you're in a worse position potentially because you've waived. You could still maybe argue the superseding intervening cause, but I just wonder how a court would interpret it. I don't know if I were the judge, I might look at this and go, well, you weren't specific as to this defense, affirmative defense, therefore the superseding intervening, I'm not contending. I don't agree that applies to this defense because you had a chance to plead this one specifically in your answer. It worries me for your industry's sake.
I appreciate your concern. I'm sort of here, not a lawyer, so I
Right.
don't.
I understand.
Our lawyer looked at this because they had looked at it, thought it was okay, but again, that's your opinion.
Let me ask you this, if this committee chooses to pass this, I think that's a question that's worth you going back to your council and talking before this bill comes up on the floor. You're willing to do that?
I'm sure if this committee sees fit to pass this bill, I will get y'all an answer, and you will have it before this bill comes up on the floor.
Okay.
Got my word on that.
Any other questions? All right, anybody want to speak on the bill? We have Senator Barnett speaking. Senator Simmons. Senator Simmons.
I have a motion.
Okay. So do we have a motion? Have a motion?
Title sufficient to pass.
Motion is title sufficient to pass. All in favor say aye.
Aye.
All opposed?
No.
Ayes have it. All right. Let's go down to, thank you, Philip. If you'll, since we passed it, if y'all will get that, Senator Tate's over there going, what'd I get into?
We should have him to drive this positive motion.
If you'll get that to us before we do that,
I'll have
appreciate it.
that to you, Mr. Chairman. I'll get y'all an answer. Thank y'all for y'all's generosity and leading me.
Thank you.
Best I could handle.
We'll go down to call up Senate Bill number 2205. This is filed by Senator Younger. Okay, it's a short bill that says, and I've had a number of people talk to me about this. Anybody who's been adopted, once they turn who's at least 18, that they're entitled to a copy of the original birth certificate. And in talking to Senator Younger and others, said in addition to other reasons, but also the health reasons, of course, you got DNA now and you got all that stuff so that allows them to know about their health records and things like that. Any questions on the bill? I have a motion. Motion is title sufficient to pass. All in favor, say aye.
Aye.
Opposed? Motion carries. All right, next we're going to go to Senate Bill number 2638, electronic documents, and filed by Senator McCon. I'm not going to pretend that I know all about that, so I'm going to turn it over to Senator McCon on that one.
Thank you, Mr. Chairman. As this committee remembers, last year you passed the e-notary bill. I believe the House version's one that ended up in the code. There's only one little area that we've got to clean up a little bit. Unfortunately, in the state of Mississippi, all of our chancery clerks cannot accept electronic documents at this time. Now, I believe there were some concerns as to how do we encourage them to do it. We want to encourage them without hurting our people out there. So this bill right here is what's called a paper out process, where after an electronic notary is implemented, which it goes into effect July 1st this year, this provides the ability for an attorney to print the document, attach a certificate, and that document now conform and be available for filing in the chancery clerk's office for deeds and leases and other affidavits of that sort. So that's what this bill simply is. It provides an actual form in there. It still has to conform with all the requirements, except that it adds in that there's now a cover sheet for that document to be filed in a chancery clerk land records. So I'll entertain any questions, Mr. Chairman.
I have one or two.
Yes, sir.
So I think it's, you and I've talked about it. I think it's good. My question is, there's a movement towards electronic filing. And I think I shared my concern is, or my question is, what is to, if this passes, what is to incentivize or keep people from backtracking or not trying to move towards electronic filing?
And I have no problem with this committee looking at how we incentivize them in the future. The only thing that concerned me with this is that in July 1st, we're going to have documents that are electronically notarized, and they're going to have nowhere to go. And I don't know, Mr. Chairman, if we need to look at a committee to do that. But I do believe that in Mississippi, unfortunately, we're not fortunate enough yet for all of our courthouses to be on board. I believe that our MEC filing last year, encouraging them or telling them that they're going to become part of MEC, was the first step in the right direction. And we may have to look at that with this as well.
Any other questions? Any motions? Do I have a motion?
Title sufficient due pass, Mr. Chairman.
Motion is title sufficient due pass. All in favor say aye.
Aye.
All opposed? The ayes have it. All right. Speaking of, we'll go to Senate Bill number 2022, or along that line rather, filed by Senator Johnson. And it's a simple bill, paragraph 2, that each justice court shall accept pleadings and other papers by electronic means in the Mississippi Electronic Court System, MEC, by July 1st, 2022. So there's a year there. So that's the bill. Any questions? Senator Turner, forward.
Thank you, Mr. Chairman. Are we saying that this is any matter that could be pending in justice court is to be received electronically?
Reading the language, yes. And I will tell you that the Justice Court Judges Association is aware of this bill out here.
Are they in agreement with it?
I don't know about that. I think, just what I reported to the committee, I think that's been reported to them and they understand where things are headed. And so I think are fine. In fact, most of the judges, there's been no opposition come to me saying they were against this bill or anything like that, either from the supervisors or the justice court judges.
So I'm trying to think about what documents are filed with justice court. So there are the tickets, citations from patrolmen, sheriff's deputies, and then the civil pleadings. So we would allow someone to make out an affidavit against another person, and that can be filed electronically.
Yes.
Who will assist them with the preparation of that document and take the oath that they're submitting?
Well, since this is meeting the Mississippi MEC system, my guess it would be like goes on in Chancery right now. If you actually go to Chancery, that the first initial pleading has to be done, filed in person there, and then everything thereafter becomes electronic. And if you'll notice in line 19, it says a party's participation is voluntary. So part of this is to allow for, so I think the parties can still file that way. It's the court system and honestly probably the attorneys and all to make it more efficient. And when I talked to Senator Johnson, that's what he said. He said he's had people come to him and talking about the inefficiency and the problems that they've had, and that's what he was trying to address with this bill.
From a practical standpoint, do we think that we can force the justice court judges to go along with this? I mean, there are Chancery court districts and some circuit court districts, I think, that are not filing electronically. So just practically speaking, I just wonder if we will be able to accomplish this.
I think so, whether that'll be tomorrow, July 1st, 2022 or July 1st, 2030.
Will it be through MEC?
Yeah, the bill's requiring it to be MEC. Yes.
Thank you.
All right. Any other questions? Do I have a motion? Motion is title sufficient due pass. All in favor say aye.
Aye.
All opposed? Bill carries. Okay, just a little, so that covers it for today's agenda. We will be meeting, the plan is to meet at our, standing meeting tomorrow. If for some